In 1522, a lawyer was appointed to defend a group of rats in court. The rats were accused of destroying a village's crops, and the lawyer, one of the most famous of his time, actually argued that his clients could not attend the trial because they were afraid of the local cats, and the judge did not laugh. He took it seriously. It sounds like a dark comedy, but in the Middle Ages, this was deadly serious law. From pigs being sentenced to death for murder to bulls being legally executed, animal trials were not just a local superstition. They were a complex, formal part of the European legal system. But why would an entire society go to such extreme lengths to prosecute an animal? Was it insanity? Religion? Or was there a darker, more practical reason behind these bizarre court battles? Today, we are opening the archives of medieval legal history to discover why your ancestors treated animals like hardened criminals. Let's dive into the crazy reality of medieval law to understand why a 15th century judge would sit through hours of arguments to decide the fate of a pig or a swarm of locusts. We have to step out of our modern, secular mindset and enter the world of the medieval European. Today, we view the law as a human construct, designed to govern human society and protect human rights. But in the Middle Ages, the law was something far more expansive, deeply intertwined with the divine order of the universe. For the medieval mind, nothing happened by chance. Every storm, every famine, and every plague was seen as a message or a direct punishment from God. When a pig attacked a child or a swarm of locusts devoured an entire village's harvest, it wasn't just viewed as a natural accident, it was viewed as a disturbance of the divine peace. If a beast committed a crime, it was seen as an agent of chaos that had to be brought to justice to restore balance. This is where the concept of legal anthropology comes in. Think of it not as a judicial failure, but as a social survival mechanism. In a world without social media, insurance, or centralized police, these trials were, in a way, the ultimate community-building exercise. When a farm animal killed someone, it wasn't just a loss of property. It was a traumatic event for the family and the village. If the community didn't see the culprit punished, the tension could boil over into personal vendettas, family feuds, or even lynch mobs. By bringing the animal to a formal court, the legal system channeled that raw, violent energy into a structured, public process. The trial gave the victims a platform to express their grief and their demand for justice. The owner of the animal was often brought to court as well, and by subjecting the animal to the same judicial process as a human, the state was essentially saying, we are a society of law, not of savagery. Furthermore, these trials served as a terrifying public education tool. Imagine you are a peasant standing in the town square, watching a pig being dressed in human clothes, a waistcoat and breeches, before being led to the gallows. The message was unmistakable and bone-chilling. No one is above the law. Even if you were just a brute beast with no soul, your actions have consequences. The sheer theatre of these executions was designed to imprint the gravity of the law onto the minds of everyone watching. It wasn't about the pig understanding the trial. It was about the humans understanding their place in a world governed by strict rules. It was a legal system that demanded total accountability, turning every crime, even those committed by creatures without speech, into a lesson on morality, responsibility, and the inescapable reach of the courtroom. To truly grasp the bizarre reality of these trials, we must look at the most infamous documented case in history. The Savigny-Sau of 1457. Imagine the scene, a small, dusty village in Burgundy, France. A young child, only a few years old, is left unattended. Tragedy strikes when a sow, a large, adult female pig, attacks the infant. The child is killed, and the village is thrown into a state of panic and mourning. In our modern world, we would put the pig down and perhaps hold the parents liable for negligence. But in 1457, this was a matter for the High Court. The sow and her 6 piglets were immediately arrested and thrown into the local prison, mirroring the treatment of any human murderer. The case was not handled haphazardly. It was a formal, multi-day trial. A judge was appointed, a prosecutor was assigned, and legal counsel was summoned. Witnesses were called to the stand to testify about the pig's behaviour, if it had been aggressive before, if it had been roaming freely, and the exact nature of the attack. Every detail of the crime was meticulously recorded in the court documents. What makes this case truly surreal is that the 6 piglets were also placed on trial. They were accused of being accomplices to their mother. However, the defence presented a compelling and surprisingly fair argument. While the sow was found guilty and sentenced to death, the piglets were acquitted. The defence argued that there was no hard evidence that the piglets had actually participated in the violence. They were merely young, impressionable and under the influence of their mother. The verdict was executed with the full pageantry of the law. On the day of the sentencing, the sow was dressed in human clothing, a custom meant to humiliate the beast and signal that it was being judged as a moral agent. She was outfitted in a waistcoat, gloves, and even trousers, giving her a grotesque, human-like appearance as she was led to the public square. Before a crowd of silent, watchful villagers, the sow was hanged, just like any human felon would be. This was not a private act of slaughter. It was a public execution. The village authorities even paid for the cost of the trial and the execution from the public treasury, treating the entire process as a legitimate function of the state. This case of Savigny serves as the perfect lens into the medieval psyche. It demonstrates that the law was not just about control. It was about performative justice. By hanging the pig in the town square, the judicial system reinforced the boundary between civilized society and chaotic nature. The villagers walked away from the gallows with the distinct feeling that order had been restored to their small world, and that justice, no matter how strange the defendant, had been served. It was a bizarre, grim theatre, but for the people of 1457, it was the only way to make sense of a tragedy. If the Savigny sow trial was a grim example of judicial theatre, the case of the rats in Autun, France, in the early 16th century, was the moment where medieval legal absurdity reached its absolute peak. And at the heart of this bizarre legal drama stood a man who would become a legend in the history of law, Barthélemy Chassenée. Imagine the frustration of the villagers in Autun. A massive swarm of rodents had descended upon their fields, devouring the crops that were meant to feed them through the winter. This was not just a pest problem. It was a matter of life and death, of impending starvation. In their desperation, they turned to the only power they truly trusted, the church. They filed a formal complaint, demanding that the rats be excommunicated, banished, and condemned for their crimes against the community. The court issued a formal summons, but, predictably, the rats failed to appear. This is where Chassenée entered the picture. Appointed as the attorney for the defence of the rodents, he faced an impossible task. How do you defend a swarm of vermin? You don't argue innocence, you argue procedure. When the trial began, Chassenée stood before the judge and made his first brilliant move. He argued that the summons was invalid because it had not been delivered properly. He pointed out that the rats lived in many different villages, and a single notice in one town could not possibly inform the entire population of rodents across the region. The judge, bound by the strict, intricate rules of medieval law, was forced to agree. The court then issued a new, local summons, but when the second hearing arrived, the rats were missing again. Chassenée, unfazed, rose once more. This time, he delivered a defence that remains one of the most famous and hilarious moments in legal history. He argued that his clients, the rats, were perfectly willing to appear in court, but they were terrified to do so. Why? Because the cats of the local villagers were waiting outside the courthouse doors, ready to pounce on them. He argued that because the prosecution could not guarantee the safety of his clients, they were legally justified in staying away. It sounds like a farce, but for the medieval judge, this was a logical conundrum. If the court was responsible for due process, it could not force a defendant to walk into an ambush. The trial dragged on for months, perhaps years. Chassenée had successfully weaponized the complexity of the law to stall the proceedings, protecting the rats while simultaneously turning the trial into a sensation that travelled throughout the province. Chassenée's brilliance lay in his understanding of the theatre of the law. By treating the rats with the same legal scrutiny as a nobleman or a thief, he wasn't mocking the system. He was upholding its most rigid, uncompromising principles. He proved that even in a world where a plague of vermin was seen as an act of God, the law was the one thing that could pause, question, and deliberate. His performance in Autun made him a celebrity, eventually paving his way to becoming the president of the Parliament of Provence. The rats of Autun were never punished, and Chassenée became the most famous lawyer in France, proving that in the Middle Ages, if you could argue the law well enough, you could save even the most guilty or the most pestilent among us. While civil courts like the one in Savigny dealt with crimes committed by animals that could be captured or killed, such as pigs, cows, or horses, the medieval legal system faced a much bigger problem. What to do with the defendants that couldn't be touched? How do you put a swarm of locusts or a plague of caterpillars on trial? This was the domain of the ecclesiastical court, the church. When a region faced a catastrophe that threatened mass starvation, the local bishop would initiate an ecclesiastical process. Since these creatures could not be physically detained or executed, the church used its most powerful weapon, the spiritual sentence of excommunication. The logic was consistent with the medieval worldview. If these animals were acting against the natural order, they must be spiritually tainted or acting under the influence of demonic forces. The trial functioned as a public, liturgical ritual. A priest would stand in the infested field, read the formal indictment against the insects, and command them to depart from the land. But the church was surprisingly bureaucratic about this. Just like in a civil trial, there were formal warnings. The defendants were given a period of time to leave the region peacefully. If they refused, they would be declared anathema, formally cursed and excommunicated from the community of God's creation. While it sounds like superstition to us today, we have to remember that this wasn't just about the insects. It was about the psychological survival of the villagers. When a drought or a plague of locusts struck, the community felt helpless, abandoned, and terrified. By holding a trial, the church provided a structured way to confront the terror. It turned a chaotic, uncontrollable disaster into a legal grievance. It gave the people a sense of agency. They were actively fighting back through the authority of the church. Whether the insects left or not was almost secondary. The ritual had successfully re-established the moral order and the people's sense of connection to the divine, which was, in their eyes, the only true way to save their souls and their harvest. When we look back at these trials, it is tempting to dismiss our ancestors as superstitious or simply insane. We look at the image of a pig in a waistcoat or a lawyer defending rats and we laugh. But if we want to truly understand history, we have to move past the judgment and look at the logic behind the madness. The medieval world was a place of extreme fragility. Life was a constant negotiation with hunger, disease, and the unpredictable forces of nature. When your entire existence depends on a harvest that can be wiped out in a single night by a swarm of locusts, you do not have the luxury of indifference. You need a system that offers an explanation, and more importantly, a path to action. These animal trials were not signs of a society losing its mind. They were signs of a society fighting to maintain order in a world that felt fundamentally chaotic. By bringing the wild into the courtroom, the medieval legal system was doing something profound. It was expanding the boundaries of civilization. It was asserting that there was no corner of the earth, no creature on the land, and no disaster in the fields that was outside the jurisdiction of law and morality. As we moved into the Enlightenment and the scientific revolution, our tools for understanding the world changed. We replaced the trial of the locust with the biology of the insect, and the curse of the priest with the chemistry of the pesticide. But the human need for justice, for a structured way to confront trauma, remains the same. These trials remind us that law is, and always has been, a form of storytelling. We use the law to define who we are, what we value, and what we fear. When we judge a pig, we are really setting the boundaries of our own human community. We are defining the standards of the good and the just, even if we no longer call animals to the stand. The impulse to find order in the chaos remains at the heart of every legal system on Earth. The medieval animal trial might be gone, but the human desire for justice in an unpredictable world is, and will always be, a defining part of who we are. History is often far more bizarre than fiction, and the story of the medieval courtroom is just one of the many secrets hidden in the archives of our past. But the rabbit hole goes much deeper than animal trials. If you found this deep dive into the medieval mind fascinating, don't stop here. I've selected a few more stories that are just as shocking, dark, and unbelievable. Click on the video appearing on your screen right now to discover other insane curiosities and mysteries from the Middle Ages that will change everything you thought you knew about our ancestors. Before you go, show your support for the channel, hit that like button and subscribe to join our community of history explorers. But don't wait, those other stories are waiting for you. Click the card now, and I'll see you in the next story.